Well, welcome everyone to the final session of Ignition Law's General Counsel Know-How Series of 2024 on pitfalls in property for startups, scale-ups, and SMEs, and how to avoid them. Our expert speakers today are Helen Lucas and Lauren O'Sullivan. Helen Lucas has been a partner at Ignition Law since 2015, specialising in all aspects of commercial real estate, including leases, property transactions, development, and corporate advisory. Lauren O'Sullivan is our property disputes resolution expert dedicated to helping clients navigate and mitigate disputes with a practical and commercial approach. I will now hand over to Helen and Lauren.
Hi guys, thank you Toby for that introduction. Hels, I don't think you're on mute. Sorry, thank you for that introduction. Yeah, we've got a lot to cover today. Lauren and I have set ourselves a very ambitious target, so bear with us. We were kind of looking at what we thought might be most useful for people today, and looking at the kind of people who generally come along to these sessions. And for a property session, in my mind, I suspect we largely group into three groups: either people who are running businesses which have a fair amount of property in them, but perhaps their original background in work is not in commercial property. We tend to get a lot of lawyers, GCs, in-house counsel for whom property probably wasn't their original specialism, but for whom they're expected to deal with property quite often. And then, of course, we'll get our own lawyers, particularly sort of corporate, commercial, finance lawyers who come across property a lot. Now, in many ways, I think hopefully what you can gain from this session will be quite similar across those groups. What we're trying to aim for today is to give you a real kind of overview, almost of like issue spotting, so that you know when you need to come to us for help, essentially. Now, in putting together this outline today, we did a highly scientific experiment. I basically emailed my lovely team of 5, and we had a little bit of a poll as to what the top 10 issues are that we come across on a kind of daily basis. And we've compiled them in a sadly not particularly festive top 10 countdown of those issues. And we're hoping to very briefly hit on every single one of them. Lauren and I naturally could go on every single one of these topics, possibly for an entire seminar. So bear with us. It's going to be challenging for us to keep it brief, but we're going to do it. Toby, do you want to move on? So yeah, I won't list them out now, but you can see on screen there's the first 5. So I'm kind of starting with number 10, and we're going to go down to number 1, which is our team's collective biggest issue. Just move on, Toby. There we are. So that is the top 10 we're going to be dealing with. So if we go back to the serviced office, there we are, clicking onto the first slide. So serviced offices, for those of you who know me or who may have connected with me on LinkedIn or have met me or whatever, serviced offices are perhaps a surprising bit of a, not a bugbear, but something that I've spent a lot of time on, as has Lauren, and we'll share why as we go through. They're actually a very surprisingly risky area, and I think possibly because it's often assumed that they're not. It's often assumed that they're very standard, they're straightforward, they're not negotiated. So often when they come across our desk, the landlord has frequently put in place a scheme in its building, all too often without taking advice on how they should structure it. And the occupier, I'll say tenant for ease, but so the tenant very often also hasn't taken advice. And this can lead to all sorts of issues, which we will flag. Now, I can only touch on the highlights today. If this is an area that particularly interests you, I have actually done an entire podcast on this. So if it's something that's relevant to your line of work, then that's on our podcast series. And we've also got a know-how guide we can share, which goes into a lot more detail. So briefly, what are they? Well, you'll have seen serviced offices, shared space agreements, co-working spaces. They also go into like similar models are used in co-living type spaces now. Typically, there will be a building or a floor of a building which somebody owns or lets themselves, and then it will be split up into a whole series of much smaller spaces, typically individual office suites, or you may have 2 or 3 office suites, something like that. They've become very popular because for many reasons, but they're perceived as giving a lot more flexibility to the landlord and the tenant. Often from an occupier perspective, you will get a much higher spec, you'll get more services, you'll get more facilities than you might get if you were taking on your first office space. From a cost perspective, some people are very attracted to the kind of community idea of working with like-minded people in that space. I know when Ignition first started, we started out in a WeWork office, for example. But they're not always what they look like. They will almost always be drafted as a license rather than a lease. And that is intended to give the landlord or the owner more flexibility, more ability to move people around, more ability to terminate the arrangement, etc. But from a landlord's point of view, there's all sorts of pitfalls they can fall into there. If they don't do it correctly and operate it correctly on the ground, they can inadvertently give their clients all sorts of protections that they weren't expecting. From the occupier's point of view, they often think that they might have a particular term or ability to occupy, and that actually doesn't transpire to be the case, because the landlord has a great deal of rights to come into their space, possibly to terminate them at their occupation early, etc. Now, I'm not going to go into break rights and things in great detail here, but you really do need to look at them carefully and consider what those are, and also consider whether your ability to remain in that space for the full term is exactly as you think it will be. I would always advise allowing us to, even if it's just an hour or two, just to give you some headline points, because there are endless pitfalls to fall into here. One thing as well, which catch people out, people often choose these arrangements because they can have great services, they can have high-end facilities, they might get meeting rooms, cafes, bars, things like that. Now, almost always these agreements will enable the landowner, the landlord, to terminate most of those at any time. In fact, one of the reasons I think for both Lauren and I this became an area of interest was because we spent much of our time during lockdown advising occupiers who hadn't taken advice, and there was certainly, not wishing to name names, but I will say WeWork were absolutely dreadful to some of our occupiers. They would keep buildings open with absolutely no supplies whatsoever, and they'd still be charging full rent, and they wouldn't budge an inch. And occupiers were very surprised that they had the ability to do that. On a similar theme, you will often find hidden somewhere in an appendix or a schedule or something that you are obliged to use a particular supplier for all of your services. So the costs of those are very much often out of your control. Now, none of this is to say these are bad arrangements. They offer fantastic facilities for a lot of people, but I would just say, basically be very mindful when you're entering them. So we just move on. I think Lauren's got a few points to add on this topic.
Yeah, thank you, Helen. So I've listed here a number of the kind of key issues that usually lead to a dispute that we come across. So the top one is in relation to termination. So an occupier trying to get out of the agreement. And as Helen kind of touched on there, we had to deal with a lot of this in 2020. And some of the key issues we see without sort of proper consideration of how the terms are drafted is often occupiers are tripped up on the automatic renewal. So a lot of these service office type agreements tend to have an automatic renewal at the end. Let's say it's a 1-year term. It doesn't just come to an end after 1 year. Typically, like a more traditional lease, there's like a notice to serve to actually end it. So occupiers can find themselves tied up if they don't spot that in time, tied up for an extra period, committed to extra rent and everything. Break rights we find are usually not that clearly drafted often, and can be trickier to operate, especially compared to a more traditional form of lease, although they definitely have their issues, which we'll come on to. But one thing we've noticed lately is that they often have requirements to serve notice by email, which on the face of it can look really convenient, and it's often a lot easier than serving notice by post, like a traditional lease would probably require. but we've come across a few issues where occupiers have tripped up. For example, requiring that the email is sent by a particular person in the occupier's company or to a particular person in the service provider's business, and then those people have moved on, and it raises question marks about how you can validly terminate. So that's something to look out for, being mindful of the termination obligations and how, if you're an occupier, you can ensure that you can exit when you want to exit and kind of have a clean break. As Helen has touched on as well, they often offer a lot of flexibility and rights for a landlord, and in many ways, like rightly so for a landlord, because they need the additional rights to ensure that these types of agreements are licenses rather than leases or tenancies, and that's a whole other area to go into. But one of those rights to ensure that it is a license is the right to move an occupier from a particular space. And we've seen some very kind of woolly drafting in the past that has led to some disputes. For example, one of our occupiers, the landlord tried to move them to a completely different building, which was a completely different spec. It was quite, old-fashioned. It wasn't as in a prestigious location. And yeah, the drafting was just very woolly and just wasn't what the tenant signed up for, basically. But the landlord was entitled to do that under the terms of the lease. So I think it's about getting very specific in the drafting. In that case, if you're an occupier and there's things you're precious about, the spec, the location, the building you want to be in, it's just getting very particular with the drafting. And then I won't go into detail on the rest. I could just speak for ages on all of these issues, but typically they have very kind of black and white predetermined rent increases, which can be beneficial for visibility for both sides. But again, in times like 2020, where the rent increase didn't match the market circumstances, so not only were some tenants not getting the services they were paying for, they were finding that the rent was also increasing at the same time in some cases. And there can be often sort of kind of quite harsh penalty payments like late payment fees. And then it doesn't come up as often in service office space agreements, but we do see it from time to time, repair and dilapidations issues, and we're going into that in more detail a bit later on. So I'll leave that one there and we'll move on to the next slide.
Okay, stamp duty land tax. I'll whip through this one. It's relatively quick for the purposes of today. So really, just for those of you who don't know, SDLT, stamp duty land tax, it is, in so far as we're talking about it, a tax in terms of property transactions, usually payable within 14 days of the effective date of a transaction, being the date of the lease, the date of the transfer, whatever it is you're dealing with. There are funny situations that catch people out. For example, if you have an agreement for lease or a conditional contract and you actually perform the majority of that contract or pay for the majority of your purchase price from your property or something like that, the SDLT can become due before the actual completion date. So there are things that catch people out there. It's not always payable purely on the price quoted. Sometimes if you have a scenario where you've got some like a transaction between connected parties, for example, even if it says that there is no consideration, you may find that the market rate or the market rent or the market value is implied. So it's not always as simple as what it says on the document. SDLT is not payable on licenses, but you need to be very sure that what you've got actually is a license and it's not just a lease pretending to be a license. There's other scenarios like implied periodic tenancies that catch people out. So this is where we often see this, where someone's been allowed into occupation and they might be paying monthly, weekly, quarterly, yearly, or whatever, and they will therefore, with no sort of lease or proper document in place, and they've actually got themselves a monthly or weekly or quarterly implied periodic tenancy and should have paid SDLT at the point that came into fruition. VAT is payable on a lot of property transactions. And harsh as it seems, you pay SDLT on the VAT inclusive amount, so you pay a tax on a tax. If we're talking leases, if you have rent reviews during the term and your rent goes up during that first 5-year period on which you assess your SDLT, then you actually have to go back to HMRC and tell them about that rent increase and go back and pay them more tax. Similarly, with turnover rents, you may not have, be very clear at the beginning, obviously, what that turnover is going to be. So you have to do an estimate at the beginning of what your turnover rent is going to be. And then at year 5, you have to go back to the revenue and either reclaim if you haven't, if the turnover has been less than you thought, or pay more if the turnover has been more than expected. As with any tax, there are late payment fees, interest to be paid, etc. if you get it wrong. And obviously, it's a very nuanced area. So we would always advise getting specialist advice on this. And we've got our lovely in-house tax team that can help you with that. We can move on, Toby. Right, registration issues, another sort of major headache. I would say anything with the land registry could definitely be number 1 on your top 10 lists of property headaches, shall we call them. It's quite embarrassing, especially when you're dealing with overseas clients and they contact you a few months after a transaction and ask why your title's not updated, and you sort of tell them, well, because the land registry's estimated date for completion is currently 2026, and they sort of can't actually quite believe it, but that is the case. You just have to be aware that various matters are compulsorily registrable. If you don't register those that are, you will end up with you won't end up with a full legal title. So things like transfers of property, leases of more than 7 years. And I have to confess, there is a small error in this next sentence, which I spotted last night. A reversionary lease, that's something where you're granting a lease now, but it doesn't take effect until some time in the future. That should actually say if it takes effect in more than 3 months in advance, then you have to register it. So even if you only had a lease that was going to be a year long, if it didn't start until June 2025 or something, you would have to register it. And obviously bank charges. Now, overseas companies, as many of you will know, since August 2022, they have to be, if they're going to own property, they have to be registered on the overseas register, and full details of the ultimate beneficiaries have to be there. You will not be able to register anything if that has not been done. So it's absolutely critical that all of that information is collected from a seller or a landlord at the point of the transaction if they're an overseas company. In terms of signing, land registry also very specific here. We can now use DocuSign, thank goodness, but we do have to provide a lawyer's certificate to say it's all been done properly. So you can't just, as non-lawyers, use DocuSign and get that past the land registry. Again, overseas companies, everything has to be signed in a specific way. If the overseas company is not currently registered as the owner or landlord, then you will have to send in company registration details, possibly a legal opinion, etc., in order to get the land registry to accept them. If there's any unregistered parties, you have to collect an ID for them. And if there's any third-party consents, like a bank consent or any kind of restriction on the title protecting some third-party right, for example, a third-party right of overage or something, then you have to present all of this information to the registry at the point of registration. Otherwise, you will either get a straight rejection or you will be dealing with endless requests for information from the land registry, which obviously can be much harder to obtain sort of 2 years after the transaction happened. Final point, plans. That's something that often catches people out. The requirement for land registry plans, very specific as to what they have to be, what they have to include. And powers of attorney, again, something that catch people out. If you've got anything signed under a power of attorney, that power of attorney also has to be legally represented. Or you have to get some ID for them. You will need a specific form of certificate if the power of attorney is more than a year old, and you need a certified copy of it, etc., etc. So whilst in theory, the land registry portal is fairly self-explanatory and anyone can have a go at it, just be aware that that's literally the tip of the iceberg of everything that they find to take fault with. Moving on, Toby. Okay, repair. So Lauren will have quite a lot to add here too, so I won't spend too long on this first slide, but whenever you're talking about repair in any context, well, in a lease context, the critical first question is to look at what your demise is. So if you have a typical room or part floor or something in a building, you will normally have an internal demise, by which we mean like an internal shell, so the inner half of floors, ceilings, walls, surface coverings, etc. You won't typically have anything structural. If you're taking an entire building on, you will have a full external demise, which is going to include the full structure, foundations, roof, etc. Now, all the time thinking in that context, what we often find catches people out is just the concept of what actual full repair means. Is often incredibly misunderstood, quite rightly so. I can understand why, but people often assume that they take the property as it is and their extent of obligation, relates to the current condition of the property, which sadly under English law is not the case, or at least under most leases is not the case. And this is something that really, to avoid issues, to avoid delays, to avoid argument, really, really needs to be addressed at the heads of terms point. So if it comes to us and it's already been signed off in the heads of terms, it's much trickier for us to resolve for you. So if you've got a property that's not in perfect condition, if you've got like an internal demise, I would always recommend getting a schedule of condition done, which essentially can just be a series of photographs, possibly with some commentary about any issues that are there. If you have a full structural demise, I would, or you're buying a full property, I would always recommend getting a building survey done. Now, that's sort of half the picture. Getting it done is one thing, but you do then actually have to loop it into your legal obligation. So in a lease, you actually do need to reference that condition shown in your building survey or schedule of condition. Often people will say to me, oh, it's fine, I don't need to do anything. I've been round, I've taken photos, we've got no problem. Well, the photos could be useful because at the end of the lease, they might show what was physically there. So they might help you to show what you put into the property and what you didn't, but they're not going to help you in terms of your repair obligations and your dilapidations unless you actually quote that in the lease and caveat your repair obligations by reference to them. On a similar theme, people often will quote at me, will surely fair wear and tear is accepted. Well, again, depending on how your lease is drafting, then ordinarily not. Again, issues that come up in a pre-lease or purchase or whatever situation in a survey or a schedule of condition, you always want to try and exclude responsibility for those. So in a lease scenario, you would try and get a landlord to do those works before completion. And depending on the nature of the works, you might try and get some kind of certification that they've been done properly. In a purchase, you might chip some money off the price if something was showing up in a building survey. But again, all of these are very much commercial points. We can argue them for you, but it's much easier if you can address these at commercial level. One thing that is very frequently overlooked in leases is what you can't see. So things beneath the surface, things like service conduits and electricity supplies and things like that, but more obvious things like boilers, air conditioning, etc. They're not going to show on a regular photographic schedule of conditions. So if you do have quite a lot of those that you're going to be taking responsibility for, then we would always recommend getting a separate survey just of those items. Moving on to Lauren.
Thank you. So yeah, repair and dilapidations are a notable area of dispute, and particularly dilapidations when we get to the end of the lease, but they do show up during the life of the lease as well, naturally. And it can go both ways. So a landlord not being happy with the state and repair of condition that the tenant is keeping the property in. And then on the flip side, the tenant wanting the landlord to carry out certain repairs, maybe to the actual premises, or if it's, I don't know, an office in a shared space and there's communal areas, maybe a tenant might not be happy with how the landlord's keeping up the communal areas, and then we're straying into service charge. but there's definitely a lot more more rights in favor of the landlord when it comes to addressing repairs during the life of the lease, and a number of like statutory remedies in its favor. But often leases without the right kind of wording aren't necessarily drafted as much in a tenant's favor, and often it can be much trickier for them to enforce against a landlord when it comes to repair issues. But definitely the most common kind of repair issue we come across is terminal dilapidation. So at the end of a lease, however it ends, a break right or expiry, the landlord will typically serve a dilapidation schedule on a tenant, highlighting things that need to be done in order to give the premises back in a full state of repair and condition, or the amount that's payable in lieu of that. And often we find that tenants are very surprised at this, and they haven't necessarily budgeted for this process because it can be quite involved. And especially if you as a tenant are surprised at the amount that the landlord is claiming, which is usually the way, you often need to engage a dilapidation surveyor to fully support you through that process and negotiate on your behalf. But again, as Helen touched on, there are things that can be done at an earlier stage to kind of mitigate against that kind of level of surprise that tenants often face. Usually it's down to how a lease is drafted and an expectation that we need to hand the property back how we took it on, but that's not necessarily the case. Depending on how the lease is drafted, you might be required to actually improve the premises. And also, dilapidations is just a tricky and involved area. The most sort of diligent tenants, no matter how well they've looked after the property, usually do face some kind of dilapidations claim at the end. So it's definitely one to be aware of, and definitely one to kind of budget for, because there'll be something to address in some way, shape or form. Next slide.
Okay, moving on to break clauses. Again, something that Lauren will have quite a lot to add on because it's an area that's often litigated. So from my point of view, I just want to share some of the things that will hopefully help you to avoid getting into that litigation in the first place. Things that we very often see overlooked at heads of terms commercial stage. Obviously here we're talking about leases. So timing of breaks, often people haven't really considered this when it comes to us. They can be structured in all different ways. So sometimes you will have just like a one-off break. Sometimes you'll have what we call rolling breaks. So possibly from the outset, or from, after a certain number of years of occupation, the tenant and possibly the landlord will be afforded a rolling break, i.e. they can break at any time on a fixed period of notice. Now, obviously, that's going to give you, as tenant and or landlord, depending, much more flexibility. From a tenant point of view, you will often find the more flexibility you ask for in a lease, the higher your rent will be, because the landlord puts a value on that. So it's a bit of a trade-off there. Obviously, you want to anticipate your future needs as best you can, because the costs of moving can be significant. So just bear in mind kind of what you think you need there, especially if taking on a longer term. One thing that people very often miss, you will often see breaks that kind of coincide with the same timing as like rent reviews. Now, that can be really tricky, because you can be in a position where you're forced to serve a break notice or miss your opportunity to break when you don't actually yet know what the revised rent is going to be. So again, worth building in either more breaks or breaks at different time, or something to give you that flexibility, so you're not kind of forced into that decision. A break can obviously be mutual, so landlord and tenant, or one or the other. Consider the notice period. This is obviously relevant to both parties. As a tenant, how long do you think that you would need to physically move out, find another property, etc.? From a landlord's point of view, how long do you think that you would need to relet should a tenant serve a break on you, because obviously you're keen to avoid any periods of vacant property. Lauren will touch on the break conditions, I know, in terms of the ones that cause most difficulty, but at heads of term stage, again, it's very tricky for us if we get heads of term signed that come through that have got break conditions in there that are a bit of a nightmare. Commercially standard, whatever people will try and tell you, is really now only payment of your basic annual rent up to date, and giving up occupation, giving up, making sure, you know, if any subtenants or other people you've allowed into occupation, making sure that they are also out. Lauren will no doubt touch on this, but innocent as it looks, you want to avoid a vacant possession condition at all costs if you can. Another thing people don't often think of, if you are dealing with a sublet, if you've got a lease on top of yours, if there's breaks in that, then obviously if those are exercised, you're going to lose your lease. So you need to get someone to look at that superior lease for you as well. And possibly consider alternatives to breaks. I mean, there's nothing exactly the same, but if you can get quite wide abilities to assign, underlet, share, etc., possibly consider whether you need a shorter term. One thing to be very aware of, if you go for a longer term, but you try and build in more flexibility of breaks, you've got to bear in mind that you will pay the SDLT based on that full lease term. You're not going to get a rebate because you break your lease halfway through or something. So you've just got to try and sort of weigh up all these issues and think about them at that heads of term stage, all of which should help to streamline and quicken up the negotiation of the actual documents. Moving on to Lauren.
Thank you. So yeah, I'd say break clauses are probably one of the top dispute areas that come across our desk. They're really tricky, as Helen has touched on, and often we find like tenants just give them a go themselves. And again, even the most diligent tenant doing the best job on the face of the lease, following the break clause instructions of how to serve it, there is just such a body of case law in the background. They're such a tricky, nuanced area that there's more to them than on the face of it. So we would always recommend, if you're going to serve a break notice as a tenant, do get advice. On the other side, if you're a landlord and you receive a break notice, it's worth looking into the validity of it, because they are definitely very tricky to operate. Some of the key issues we see are the drafting of the break notice and ensuring compliance with the service provisions. So typical service provisions, they differ in each lease, but they do typically require service by post, for example, and in a particular method. And often some tenants think that by email is okay, or perhaps they get the timing a little bit misaligned and don't count the days it will take to post a notice, for example. All of that is critical to sort of follow to be able to serve the notice correctly and then exit the lease. Also, there's very specific requirements. There is actually some case law that says if the lease says the break notice has to be on blue paper, then it has to be on blue paper, and a break notice has failed for not being on blue paper. That's how particular and wild they are. So it is really important to follow any instructions on the face of the lease. And then the trickiest area is compliance with break conditions. So typical break conditions might be the tenant can exit provided they serve 3 months notice, and at the end of the lease they've paid all of the rents, they provide vacant possession, and hand it back in a good state of repair and condition. They are the tricky conditions that are a bit more outdated now that Helen has referred to. Really, the standard conditions a tenant should only ever agree to are giving up occupation and maybe payment of pure rent, but nothing else. But we do see, particularly in older and longer leases, that these trickier conditions do still exist, and we've seen them trip up tenants many times, unfortunately, and we've on some occasions have been able to negotiate good helpful settlements on the other side. But obviously it's easier if you just like try and comply at the outset if you're at a point of serving and there's these conditions, or try and not to negotiate these conditions into the lease to start with. Yeah, I'm just touching on vacant possession, for example, as one of them. Again, there's a whole body of case law in the background as to what that actually means. It doesn't just mean leaving the property, getting your staff out of the premises. It's very, very nuanced, and there have been cases where even where a tenant has done a diligent job of exiting the property on time by the break date, and they've left some wiring in there that they were supposed to take out, that has meant that the break failed and they were committed to the lease for a number of extra years. So yeah, the importance of it really is exiting properly so that you're not tied up to extra rent payments and extra obligations as a tenant. And then on the landlord side, it's in receipt of a break notice, sort of reviewing the process and the validity to see if you can gain any leverage depending on how the tenant has handled things. Okay, next.
Great. So unexpected costs, obviously it goes without saying, if you're buying a property, letting a property, or occupying it in any way, it's critical to do all your financial due diligence carefully before coming to us. Things that often catch people out in a lease scenario: service charges. You will often be quoted in heads of terms a figure per square foot for your service charge. That is, that might be the figure as it is at that precise moment, but service charges can go up and down. They're based typically on estimates of what the landlord thinks it's going to spend, and then you have some kind of true up later in the year of what they actually have spent. As a tenant, if ever it's possible, you should always try and go for a cap in your service charge at heads of term stage. You're not going to get it agreed unless you get it in those heads of terms. The landlord, once it sees you've agreed a commercial deal, is highly unlikely to backtrack from that. Even if the cap is set at a level that is higher than you're expecting, at least you know it can't overshoot that if you get it in there. You forget that as a tenant occupying, a relatively small part of a building, if the roof were to suddenly dramatically fail or something, 3 years into your 5-year term, you could be whacked with a percentage of a huge cost of repairing that unless you have that cap in there. So it's really important to factor in, looking at the building, what you think might arise during your lease term, doing really careful checks of past accounts, seeing what the landlord's like, speaking to other tenants. How does the landlord run its service charge? Are they generally decent, etc.? If you're lucky enough to have a landlord who will agree to comply with a service charge code, then you have a lot of protections, because there's a lot in there about how the landlord has to operate its service charges, and that gives you a lot of reassurance, but many landlords will be reluctant to do so. Other things slightly different, like an estate service charge. If you are on like a retail park, for example, and you have like a full building or a full unit on that park, there's going to be an estate service charge for upkeep of roads and communal services. Sometimes you will see like a common expenses clause in a lease, which catches people out. This is in theory designed to deal with costs that might be shared with other buildings, but I've seen them generally used as a bit of a catch-all, sort of trying to step outside of those service charge caps that might have been included in there. So they need to be carefully thought through. Issues that come up a lot: utilities. Do you have, as occupier, have you got a meter in your exact space? Or do you risk the fact that you could be having to contribute to the pooled cost of resources, and have you got somebody next door who's got a huge utilities cost because of the nature of their business, for example? Landlords will sometimes insist on a particular supplier being used, or they might even have their own supply in the building, in which case we've seen scenarios where effectively there's a monopoly, and sometimes the landlord has some kind of deal with the supplier, and the tenant ends up really sort of paying over the odds. So I've seen that on both purchases and leases, where you really have to look at it very carefully. Business rates, obviously, you need to be fully aware of, and on rent deposits, we'll come to that, but one cost that often catches people out: landlords will try and get you to pay all their bank charges for sort of operating their rent deposit account, which can definitely catch quite a lot of people out. Talking of which, we're moving on to rent deposits and guarantors. Again, Lauren will add quite a lot here on disputes, but heads of terms points, things we end up arguing about that would have been avoided and would have speeded things up if they could have been agreed commercially. If the heads of terms say 3 months rent, let's give you the example that there's £10,000 a month rent. Does that mean it's £30,000 fixed? Or does it mean £30,000 plus VAT? If you've got a rent review partway through your lease, is it £30,000 then subject to the review? Do you then have to top up the rent deposit after that review, for example? All of these things very rarely thought of at heads of term stage. Lauren will talk about kind of the return of the rent deposit and the arguments that happen around that. But one to be aware of, as a tenant, you might want to negotiate in, again, at heads of term stage, can you get to a situation where the rent deposit might be released if you are able to meet a profits test, for example? What if your profit hits 3 times the level of annual rent at a certain point during the lease? Can you get a scenario negotiated in where your rent deposit would be released in that situation? Again, just from a cash flow point of view, from a tenant, that can be incredibly useful. In terms of guarantors, I mean, I would always totally advise against putting up any form of personal guarantee if you can, just because obviously if it's a company guaranteeing, it's limited to, the guarantee is going to be limited to the assets of that company. But if you've got a personal guarantee on there, that's obviously a high personal risk. It's also really tricky when you're dealing with any kind of business or asset sale, because you will need to find a replacement for that guarantor, which might not be easily obtainable. So, I mean, wherever possible, I would avoid a guarantor. If you have to have one, just make sure that it's a company that make sure that you're frankly certain that the tenant is going to comply, and that the company giving the guarantor, is sufficiently related that they're happy to do so. So moving on to Lauren and disputes.
So most disputes naturally arise at the end of the lease when a tenant is expecting the rent deposit to be returned, and then the landlord naturally wants to keep hold of it while it assesses the tenant's compliance with the lease terms, particularly in relation to dilapidations. And that's the point that we see most disputes arise. Maybe the lease will say the deposit will be returned within, I don't know, 1 month of lease expiry, but usually there's some kind of requirement subject to the tenant's compliance with the lease obligations. And that often includes compliance with repair, which therefore means that cannot be fully addressed and resolved until the full dilapidations process has gone through, which, if there is no settlement negotiated at quicker rate, can often be at least 6 months. And so a tenant is kind of left held hostage without their rent deposit back while that's resolved. So we have on occasions at earlier stages been able to negotiate into the lease where this provision doesn't exist, and the deposit will be released notwithstanding the dilapidations process. But naturally, with a landlord hat on, it is a form of security for a landlord, and they want coverage just in case there's a huge dilapidations claim, or the tenant just kind of runs off and doesn't pay or whatever. So it's a tricky one, but we have at earlier stages been able to negotiate that in. And at the point where it has reached a dispute, again, ideally you don't want to be in this territory, and it's kind of just a case of negotiating a suitable outcome and or dealing with dilapidations as quickly as possible from a tenant's perspective to get that released. And we do see some disputes during, I guess, the life of the lease as well, where a landlord might draw down on the deposit for some reason during the life of the lease. Maybe there's been a short period of rent arrears or something, and then they require the tenant to top up. There's usually top-up provisions in a rent deposit, and that can often lead to some, depending on the circumstances, some dispute situations as well. Okay, next.
Okay, third-party consents. I mean, this is very broad. There could be any number of issues at play here, but the ones we probably see most frequently causing delay in a lease scenario, consents for alterations, which we're going to come on to in more detail. In a sublease situation, or if you are buying the assets of a business and you are taking over those leases, there might be a superior landlord consent to get, and you've got to factor in the fact that the superior landlord is unlikely to be commercially interested in your deal. Therefore they're not going to necessarily be operating on your time scale. So you can't assume that because you want to complete your sublease in 3 weeks' time that the superior landlord is going to be on board with that and sort of, do everything it needs to do to provide you that consent. Where you have got a third party like a landlord, a superior landlord to consent, you also have to bear in mind there will be costs associated with paying for their legal fees, their advisors' fees, etc., for getting that consent. Very often in a lease or a purchase or any transaction involving property, there will be a bank involved. You will often see a restriction on the title, the land registry title, in favour of a bank, and you'll have to get that consent. Now, normally a bank consent will be relatively straightforward to get, provided they're happy with the deal that's being done. But I have seen scenarios where banks have really dragged their heels if anything slightly unusual is being done, that it's you can get yourself into a kind of computer says no situation. In some cases, banks will require, for example, if a new company is coming in or they're getting some new security or something like that, they might require a whole load of due diligence or reporting or something to be done. And you've got to bear in mind that all of these are going to add to cost and time and delay. So to the extent you have any of these third parties involved, I would always advise, we need to get in touch with them right at the very outset and not leave this as kind of an afterthought, which would be highly likely to delay matters. I mentioned title restrictions. You might have a title restriction protecting the benefit of some covenant on a property title. You might have it protecting some third party's right for some overage. You might have an individual beneficiary in a trust scenario that there's a title restriction on there, all of which will have to be dealt with at completion in order to get your property transaction registered. In some scenarios where you have like a unit on an estate, for example, you might have to become part of a management company when you purchase a property. So again, early engagement with management, estate management company, any third party like that would be well advised. Moving on, now contracting out, I mean, this relates to the 1954 Act, which many of you will know, but for those of you who don't, broadly speaking, the idea behind this act was to give business tenants protection such that they could remain in occupation if they were running their business from a property, having invested a lot of time and effort and expense into that property beyond the end of their contractual term. Now, I would say acting for a lot of tenants, in the majority of cases, the landlords actually insist that this is contracted out, so that the provisions of the Act do not apply. From a tenant's point of view, this is just a process that has to be gone through, and it's something else that has to be ticked off before completion. The landlord will serve a notice on you. You have to then trot off to an independent solicitor somewhere, which obviously, if we're acting for you, can't be us. And you have to actually swear this declaration in front of them to confirm that you understand that you're giving up these rights. It can be done in a simple notice way, but then you have to wait 2 weeks before you physically complete the lease. So that's not so often done. Now, for some businesses, if you're putting a lot of money into your property, for example, like a leisure operator that might be putting a lot of expensive kit in, they are going to try to have those 54 Act rights. They're ideally not going to want to contract that out. So again, at the heads of term stage, do think of that and do think whether that's acceptable for you as an occupier to lose those rights. And from a landlord's point of view, think of, if you allow someone to have those rights, think of the fact that it's going to be a real potential headache to actually get them out at the end of the term, should you need to. Moving on. So conscious of time, I think we've timed this quite well, Lauren, I think. Looking at alterations, I would say, which is why it's number one on the list, for me, this is probably the one I see most often delaying, certainly lease transactions anyway. I have lost count of the number of times I've said to tenants and occupiers at the beginning, do you need to do any works? And they'll often say, oh, no, not really. No, I don't need to do any works. And I'll sort of ask them a bit later, do you need to do any works? Oh, yeah, well, we've just got to do X, Y, Z. And they don't, well, it's a bit of a chicken and egg thing, because I understand that people don't want to go off and get detailed plans and everything drawn up for works unless they're quite sure that they're going to get this lease, for example. But equally, it's such a common cause of delay. The number of times I've sat with lease documents, etc., all fully agreed, and the work's not approved by the landlord as yet, countless. You've also got to factor in this whole concept of whether something is inside or outside of your demise. Now, sometimes the tenants will come with some basic ideas of what they want to do. And then, for example, a restaurant operator won't have factored in that they've actually got to go out, for example, through an external wall to put an extractor fan up, which means they're going outside of their demise. Now, in that case, the license to alter from the landlord will be a lot more complicated than if you're just doing minor works inside your demise. So you, more than many cases, I've had a scenario where we've agreed a license to alter, and then this sort of bombshell drops and we have to start again and agree a whole different document. So, I mean, the message really in terms of alterations is just to be on it right at the beginning and make sure that you get all the details over to the landlord. Way leaves, I would say, even bigger bugbear, that these people sort of think that way leaves will be fine. You just need to get, BT or whoever it is to come in and they'll put your wiring in and it will be fine. Rarely is that the case, I would say. With a way leave, you've got to bear in mind that not only are you dealing with some kind of statutory operator who's going to give you a document that's potentially incomprehensible, or if you can read it, is going to be incredibly one-sided, but also they're going to have to go into a building and they're going to have to go through walls. They might have to go through other people's properties. The landlord is going to be very worried about disruption and disturbance of its other occupiers, but also being stuck with this kit at the end of the lease term, because often they will be, and how that's going to then impact their future use of the property. So if there's even a sniff of a way leave in a deal, that cannot be dealt with early enough. Just to really emphasize that. Moving on to Lauren, last few minutes on things that go wrong.
Yeah, final slide, nearly there. I think so. Naturally, a lease contains a lot of obligations around what a tenant can and cannot do, obligations and restrictions when it comes to alterations. So if a tenant wants to carry out alterations during the life of a lease, it's important to check what they can and cannot do and seek consent if what they're proposing is beyond it, or seek consent in any case. There's usually a requirement to get the consent of the landlord, but if they're doing something above and beyond, then they'll definitely need to negotiate with the landlord, and potentially it may not be permitted. And then other consents, you might need to consider planning and access. For example, if you might be trespassing on other people's land, as Helen has already touched on. And then really where I see most of the disputes arise in relation to alterations is at the end of the lease during the dilapidations phase. Again, I feel like I've spoken about dilapidations so much here, but when it comes to reinstatement and what the tenant is required to do. So if it's put in some alterations, let's say it's installed a mezzanine, is it obligated to remove those alterations at the end of the lease or not? Because from a tenant's perspective, that could be very costly, removing something. From a landlord's perspective, they may or may not want it removed, and often a landlord has wide rights. And that's another point, timing. Typically, a landlord will have wide rights to require that something is removed, and they can communicate that. A typical clause would say, I don't know, not before the last 3 months of the end of the term, but it might be too late for a tenant to actually remove that in time, and then it will face a financial claim for not doing so. And the other tricky point we see around this is where there's a lease renewal. So maybe the tenant's really happy with the premises and it negotiates a new lease with the landlord. It's easy for reinstatement and alterations to be looked over at that point. But if it isn't addressed explicitly in the renewal lease, the default position is that any alterations become the landlord's property. They become part of the premises, which can be an advantage or a disadvantage in different circumstances to both landlord and tenant, depending on what's going on. In the case of a mezzanine, maybe a tenant's quite happy with that because they thought it would be a pain to reinstate anyway. But on the renewal, it does, if it becomes part of the landlord's property, then it will also be rentalized. So in any rent review, they might be paying for the cost of that, for example. So there's different pros and cons, but that's definitely a biggie to be aware of. Yeah, I'll leave it there. And I think that brings us to the end.
I think it does. Now, no one's put any questions in the chat, so you're very welcome to, or we have got a couple of minutes if anyone's brave enough to ask a question.
I've got a question.
Yes.
Firstly, Helen and Lauren, thank you both. That was really interesting, particularly as a non-lawyer as well, but I just found that really quite fascinating, some of the points you raised. Bit of a general question for me is, have you seen terms in leases being, or landlords putting forward a lot more favourable terms in the post-COVID environment to get tenants back in? So tenants are not having to necessarily, well, I suppose it's more of a tenant's market than a landlord's market, or is it sort of as it was pre-COVID?
I think certainly originally post-COVID and sort of almost during COVID, you would see nice clauses in there that if a pandemic happened again or something similar, you'd get rent freeze and things like that. But that was definitely a passing phase. I don't really see them in leases anymore. I always say you can kind of date a lease without looking at the front of it, depending on when some of these little quirky terms are in there, because you can see. So we had that quite a lot. And of course, in some markets where they're struggling, they will offer really big rent freeze and, you know, contributions to fit out and things like that. But I don't feel like overall terms have dramatically changed. It's still a very landlord-friendly sort of regime in terms of property lease drafting and things like that.
That's interesting. Thank you.
Anyone else have any questions? You're absolutely welcome to contact myself, Lauren, or any of our team members. I think all the details are on. I think there's a slide with our details on, Toby.
Cool.
There.
Yes.
So do reach out and contact any of us. We will obviously send round a recording. We can share that after, once it's been done. But if no one has any questions. No?
Brilliant.
Thank you both.
Thanks for joining us. Thank you. Bye.
Thank you.
Thank you.